I just want to make sure it's started. Yep, it's all good to go. Okay, I think we're all set. So let's get on the record. This is docket 5780 TE 111, the application of the City of Sturgeon Bay for approval of revisions to its parallel generation tariff. This is Michael Newmark, Administrative Law Judge for the PSC. We're connected through Zoom with parties and commission staff. And we've made the connection available to members of the public, but I do not recognize anyone connected so far as a member of the public. We did notice this for the May 7th hearing, and we have adjourned that session, reconvened here today to take the evidence of commission staff and parties. We do have a significant number of public comments submitted in writing. And on the May 7th hearing, we did not have any public comments received, although we made an opportunity to do that on May 7th. So suppose if a member of the public does show up, we can take their comment at the end of the hearing today, but I don't really anticipate that. So for that reason, let's just move on to the the party session. And just to note, we have closed the public comment, the written public comment opportunity that was closed on May 9th. But if someone does show up from the public for a comment today, we can take that. So in the meantime, let's move on with the appearances from parties and staff. And I have the service list here up on the screen share. So let's begin with commission staff.
Sophia Rogers, attorney for commission staff.
Okay, and for Renew?
Ori Walsvik, attorney for Renew.
And Sturgeon Bay.
Kira Lair and Jacob Neely of Perkins Coie for Sturgeon Bay.
All right, great.
Can I just say, Mr. Walsvik, if when you take your mic back offline, if you could let yourself finish speaking first before you click the button, because you cut off a little bit.
Oh, sure.
I meant to say that last week, but I didn't. Thank you. Sorry.
Go off the record just for a second there. So it's advised if you unmute, if the attorneys unmute, so that in case you're raising an objection, you don't have to pause for that. So it is recommended that attorneys stay unmuted unless there's some kind of disturbance in the room and you don't want it going over the mics. That's part of the supplementals, the Zoom supplement for the FMO to stay unmuted, I believe, if I remember right. Okay, well, having said that. Okay. So I'm going to move our screen share over, but before we get into the details here, is there anything we need to review, any outstanding matters that we haven't discussed from the last session? I do have a couple of notes for new comments for the filings here, just related to the Nodler surrebuttal. Was able to review that and did notice a couple of filing requirements that we wanted to add into that, and just some minor things. Just there's some commission orders cited at page 10 and 16. You could just add the citations to that, the way we format that normally. And Nodler 8 does have a hyperlink. I know it's not live, but that doesn't really matter anymore in our new system here. So just add the NRE citation to the cover page, and that should work for Nodler 8. Besides that, we don't have anything to review. Obviously, we have the motion that we decided in the last session, so we'll need to see the refilings coming in as scheduled, with the that includes the surrebuttal from Cal to be redacted, And I don't mean redacted confidential, I mean redacting what we struck should appear as redacted text. And also for Nodler, looked like from the email we received from SBU that there's a portion of that testimony that will not be submitted, not be offered. The portion that responds to the stricken sections of the Kell rebuttal. So when that gets refiled, just redact that those pieces as well, from both the confidential and the public versions. Any question about that process? Okay. I think that's all we need to review with the filings. So we can just take note of who is appearing here today, which witnesses are appearing that have no cross at this point. Possibly Stawicki. So is there any cross for witness Stawicki?
None from Renew, Your Honor.
Okay.
None from commission staff.
Okay. So unless the witness has additional testimony to add, we can I'll accept that what's been filed in writing. I'll accept that with an affidavit of verification. But it's up to the utility if they want to call that person or not. I'm assuming Cal, well, there'll be questions for Cal and questions for humans. Or additional testimony possibly, so we won't excuse them yet. Nodler, I'm sure there'll be questions for, I'm assuming. Although feel free not to ask questions, that's fine. All right, so at this point, I think we can just move into the taking witnesses. Anything I'm forgetting here?
Your Honor, if I could just clarify, so I heard you say that I think all of Mr. Stawicki's testimony and exhibits up through and including the Sir rebuttal are they entered into the record at this point?
I can receive them pending the affidavit, or you can call them and have him verify.
He is here. If I could just go ahead and and I'm mainly trying to make sure that we don't have to read any of the Sir rebuttal at this point. That is considered evidentiary material, like the remainder of the written testimony.
Right, I'm accepting it as filed.
Okay.
Yeah, filed as if read. How about that? That's probably the most precise way to say it. All right, so we have witness Stawicki in front of us there.
Yes.
Okay, great. Just want to make sure. Do you understand that, Debbie?
Yes.
Yeah, okay. All right, so let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
And Mr. Stawicki, did you prepare or cause to be prepared direct rebuttal, Sir rebuttal testimony and 2 exhibits in this proceeding?
Yes, I did.
And is the information therein true and correct to the best of your knowledge?
Yes, it is.
Thank you. No further questions.
Okay, just double checking any cross. No, better
No,
not happen. Okay, all right, witness is excused. Thanks.
Thank you, Your Honor.
SBU would call Mr. Noldner.
Okay, witness Nolder, I'm going to swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, go ahead.
And Your Honor, again, just clarifying, Mr. Noldner's Sir rebuttal testimony as read with the modifications sent around on Friday is good.
Yes, I'll accept what you just said as if read into the record.
Thanks. Mr. Noldner, did you prepare or cause to be prepared direct rebuttal, Sir rebuttal, and 8 exhibits in this proceeding?
Yes, I did.
And is the information therein true and correct to the best of your knowledge?
Yes.
Mr. Noldner is available for cross.
Just off the record for a second, can everyone hear witness Nodler? Noldner. Well, maybe
Yes.
just get your, yeah, is that okay? Okay, maybe I'm gonna turn up my volume. Maybe that's my problem here. Okay, let's start with Cross. I believe, Renew, do you have questions for the witness?
Yes, Your Honor. So good afternoon, Mr. Nolder. I'm just going to ask you some questions here. I think we're going to start with PGS 1, if that makes sense to you. It makes sense to me. So I think Mr. Kell stated in his testimony that you have SBU has very low participation in the PGS 1 program. I think he marked it near 0.4% of customers. Is that right?
That is approximately right. I did not do that calculation, but there's about 40 customers I understand. And out of 9,000, so
Thank you. And I can only imagine that was lower in 2019.
yes, it was.
So it's not really fair to say that Sturgeon Bay Utilities is a hub for residential solar energy installations.
Is that a question?
Yeah, do you agree with that?
I would say that, well, it depends on how you look at it. There's a low penetration rate right now, but if you look at how much it has increased since 2019, it's approximately doubled since 2019.
Okay, let's go off the record for a second. So I didn't know, where's that? Are you quoting from the witness's written testimony when you asked that about the
I'm
hub?
not quoting, Your Honor.
So your comment was just agreeing asking if he agreed with your characterization that you just provided.
Yes.
Okay, I guess I don't see quite how that relates as cross, but let's proceed. I think what we typically do is we pick out the statements from written testimony and then ask about that. And if you have
Sure.
a different way of doing it, then you just gotta let us know what.
Sure, Your Honor. We can go if you like. I'm trying to get at. We can look at rebuttal SBU Noldner at page 17. Just looking at the urgency for the change in the rate design here for PGS 1.
Okay, we're off the record right now, so just wanted to.
Oh, yep. Okay.
You said page, what was that?
17. And I believe line 5 through line 11, or line 3 is the question.
Okay, so I guess just in terms of I don't want to be picky. I'm just saying, if you're going to be asking about a statement like that, I'm typically going to expect that to have been the witness. Someone else has stated that as fact in the record, and you're asking for an opinion or an equivocation one way or another from the witness you're crossing. So just be aware of that. Okay.
Sure. Thank you, Your Honor.
All right, let's get back on and go ahead with your next question.
Sure. So we're at 17 in rebuttal SBU Noldner, lines 3 through 11. And so I think here you say SBU is trying to modify its rate for nearly 5 years. Have customers complained about this rate design, Mr. Noldner?
Your Honor, I'm going to object. There's no foundation that this witness would be aware of what customers would have complained about.
Any response?
I guess to the extent he's aware, I'd like to know.
Yeah, I'll overrule the objection just as foundation, I suppose. So go ahead and answer that, please.
I am not aware. The customers don't call me.
Okay, thank you, Mr. Noldner. We can move on. So I think the rest of my questions basically boil down to, it looks like you've recommended a change to PGS 1 here, and the applicant has applied for a change. So my question is, would you have recommended the same change if one residential customer had solar?
Objection, calls for speculation and also unclear. I'm not positive exactly what he's talking about.
Yeah, you'd have to clarify that and maybe provide some other background foundation for that question. I'm not sure. I agree.
Well, Your Honor, I think the background is in 2019. There
Why
was
don't we? I think we want to ask the witness to set up this question more clearly. So
Sure. So in 2019, SBU applied to change its PGS 1 rate. Isn't that right, Mr. Noldner?
That is correct.
And you state in your direct, but also in your rebuttal that you're coming back in to modify PGS 1 after being on pause for 5 years.
We are coming back in to modify one part of PGS 1, which is the rate that the utility SBU pays for excess generation beyond what the customer uses over the month as a whole.
Right. And we just discussed earlier how you have near around 40 customers, I think it is, on the PGS 1 rate, 0.4%, somewhere around that number. Is that right?
Yes, approximately that is right.
And so my question is, the impetus for this statement that this rate needs to be changed, I'm asking, would you still recommend a change if you had one customer on the PGS 1 rate?
Objection, Your Honor. I don't see the needs to be changed, and I don't not making the connection.
Yeah, that's so I agree with that. Yeah.
Okay. So
Well,
okay, Your Honor. So I guess what is your basis for the need to change the rate now more than ever?
Object again, mischaracterizes the testimony, not what is being said.
yeah, sustained. I think it's in the testimony, the rationale for the application, but
Okay, but I'm asking about the speed. So there's this allegation in the testimony that something has happened, Your Honor, and nearly if we're looking at the as explained in rebuttal SBU's to Wiki, that's line 6 on page 17 of the rebuttal. SBU has been trying to modify its PGS 1 tariff rates for nearly 5 years. And in the first line there is SBU strongly disagrees with renewed proposal that SBU wait, again, for completion of an investigation before its PGS 1 tariff rates can be modified. So to me, that's language of urgency. And so I'm trying to understand the need for the urgency here. I'm trying to identify some urgency here.
I think that the issue is that characterizations are being made, and that if he wants to ask particular questions about the testimony, it's right there.
Okay. So there's, I guess, if the reasons for the urgency are the ones identified in the testimony, that's okay with me, Your Honor.
okay.
So Mr. Noldner, are you aware that the commission is currently investigating net metering in docket 5 EI 157?
I am, but that investigation is much more broad than what has been requested in this case. We're not changing the netting. We're changing only or proposing to change only the compensation for excess beyond what a customer uses in the month as a whole. That's already been handled for the investor-owned utilities, And Sturgeon Bay Utilities is only asking that the same treatment be applied to it.
Okay. And are you aware that that investigation could potentially change the compensation rate, the excess compensation rate as you described, or any of the rate design structures associated with the residential net metering tariffs?
The commission can do whatever it wants with that case. Yes, those could change, but that's always the case.
Okay. Okay.
All right.
Let me just check anything else here. Generally just going to hop to Sir rebuttal, looking at page 3 and 4.
Okay, I've got page 3 up here.
And I don't know if Mr. Noldner, you need to take some time to look at page 3 and 4.
I'm there.
Okay.
If you have your question, I'll have to read.
You're not an attorney, right, Mr. Noldner?
I am not.
How are you familiar with Order 69?
I am familiar with what is written in my testimony,
Okay. Have you read Order 69 in its entirety?
not in its entirety.
And what about the City of Longmont case, which is cited on page 4? Have you read that in its entirety?
I have read a summary of it.
Okay. What about the Carolina Power and Light case?
Likewise, I've read a summary of it.
Okay. Isn't this just legal analysis, Mr. Noldner?
Objection mischaracterizes testimony.
Confirmed.
Okay. I don't have any further questions then, Your
Oh.
Honor.
All right. Well, thanks.
Thank you.
Any questions from commission staff?
Yes, Your Honor. All relating to the Sir rebuttal.
Okay.
Starting on page 3. At the top of the page, there for over 2 decades. Are you aware of a WPPI member utility applying to the Wisconsin Public Service Commission to set parallel generation buyback rates at a value other than WPPI's avoided costs?
Can you restate that?
Let's read
Yeah.
it back.
And
We can read it back.
oh, sure, thank you.
Question starting on page 3 at the top of the page there for over 2 decades. Are you aware?
Your Honor, I'm sorry.
Yeah.
Would be cute.
You're cutting in and out. Maybe put your microphone closer. Yeah, try that. We'll see.
Is that better?
Yeah, now it is. It just kind of
I
it
can't
cut
hear
in
you
and
guys.
out. Like,
So
you can or no?
how about this?
It's better now. So far since you moved the mic, it's been okay. No?
Starting on page 3 of the better?
Yeah. Go ahead.
Starting at page 3 at the top of the page there for over 2 decades. Are you aware of WPPI meter applying to the Wisconsin Public Service? I'm sorry. I have a big box in my way. This happened. I have mechanics and I don't think that's right. Is that right, Ms. Rogers?
Wisconsin Public Service Commission, and I'm happy to rephrase my question.
Did you
Go
wanna-
ahead because I just have a box in the way and it's hard for me to read it. I really apologize.
Not a problem. Yeah, why don't you ask that again?
And I'll back up and just review the part of your testimony that I'm referring back to. So very end of page 2 and top of page 3. You say, for the over 2 decades, I've been working in this industry and been aware of commission treatment of WPPI member utility parallel generation tariffs. I've never known the commission to do anything other than to set a WPPI member utilities PGS2 avoided cost rate for excess generation from a BTM COGS at WPPI's avoided costs. So my question is, are you aware of a WPPI member utility applying to the Wisconsin Public Service Commission to set parallel generation buyback rates at a value other than WPPI's avoided costs?
I am not. I think that's what the testimony says too, isn't it?
The distinction I'm looking to get at is what's been approved versus what's been requested.
Oh. I am not aware of that, no.
You're not aware of what's been requested. You're not sure whether anyone has requested anything other than what you describe in your testimony as being approved.
Right, I'm not aware of any WPPI municipal utility asking for something other than WPPI's avoided cost in its PGS2 rate.
Thank you.
Yes.
Pages 6 and 7, again, the turn of the page, bottom of page 6 to top of page 7, and I'll again read this out if that works. For SBU, the customer meter tells the utility only how much energy is flowing in or out from the customer, not how much energy is being produced by their generator. Did I read that correctly?
You did.
So my question is, could excess generation from an SBU customer cause fewer electrons to flow onto the SBU distribution system from WPPI or through the WPPI meter?
Yes, the WPPI meter is at the substation that serves Sturgeon Bay, and there's probably a number of those. When the excess generation comes through the customer meter onto the distribution system, physically, that reduces the flow from WPPI or from ATC, which is WPPI's flow. Now, as far as what happens to that excess generation, under our member contract, WPPI has the right to buy that energy from Sturgeon Bay, who buys it from the customer, and then WPPI uses that energy to supply load at Sturgeon Bay. So the amount of energy that Sturgeon Bay buys from WPPI stays the same, but the delivery point isn't through the WPPI meter anymore. Part of it is coming through that customer meter, and it's financially sold to WPPI and then back to Sturgeon Bay.
And I just ask to clarify that when you said WPPI has the option to purchase that energy, is that something so it can refuse to purchase, or did you mean to say it's required to make that purchase?
WPPI has the option to do it under our contract terms. Now, if it's a tiny amount, sometimes it would cost way more to implement that than it's worth.
And except for that circumstance, what would the result be in the situation you're describing, that WPPI would purchase the energy?
Yes, the normal situation, if it's of any size, WPPI would purchase the energy.
Can you give us sort of a number in terms of what you mean by size?
I can't really, because what is important is not only the size of the generator, but the size of the load of the customer.
Mhm.
So how much surplus is coming onto the system is of more concern than the size of the generator itself.
Well, we're not just talking about the surplus then?
We are talking about the surplus, but usually when we think of these installations, we talk about them in terms of how big is the generator.
Okay, but in the actual instance of the transaction, would there be an amount of surplus that's de minimis and therefore not involved in that transaction, or is there a kind of a threshold number that you'd be looking for?
That we haven't firmly established that number. We definitely do buy back, but I don't know where that threshold exactly is for Sturgeon Bay.
Is it something? Do you know that for other member utilities, or is Sturgeon Bay an outlier in that regard?
It's not an outlier.
Okay.
There
So
just
Oh.
there haven't been very many PGS2 cases.
Mm-hmm. Okay, so is there any kind of written policy as to how, I guess in the situation you're describing, or it's just something that occurs without prior guidance from anything that WPPI has set?
Well, over time, it has been about 100 kW, but that's changing as more of these customers come onto the system. The PGS2, the PPI and its members reevaluate those policies.
Okay, so there is a policy in some respects to purchase over 100 kW.
That has been the case in the past.
Would
It's
it
not
just be
our task going forward, though.
is it more of a practice? Is that
It is, and it depends, like I said, the level of interest it gets depends on how much the surplus is. The 100 kW I just referred to as the size of the generator.
Oh, okay. And that would just be across the board for all members.
Yeah, yes, when we implement a policy, we apply it to all members because we want to keep it fair and consistent for everybody.
And just to nail this down to the end, so that policy is that a written policy or is it something just done in practice?
It's done in practice.
Okay. All right. Sorry for the interruption. Go ahead, Attorney Rogers. Hope I didn't ask any of your questions.
Not at all.
Okay.
I have to say, this discussion is quite different from my understanding in reading this testimony. I had been understanding the discussion of Order 69, et cetera, as saying something quite different from what I'm hearing today. Am I understanding correctly that your position, Mr. Noldner, is that WPPI does not have to purchase from a qualifying facility? I'm sorry, does not have to purchase from a qualifying facility if it's under a certain size threshold?
No, if I understand your question correctly, the qualifying facility has to be purchased from, and Sturgeon Bay in this case would purchase from the qualifying facility. Once that purchase has been made, where there is an option involved is whether WPPI buys that from Sturgeon Bay, which WPPI would do if it is of any size, or whether WPPI passes on that because the level of surplus is so de minimis that it costs more to implement the billing than it's worth.
So what you've just said, someone is purchasing, regardless of who's handling the bill, someone is purchasing no matter what the size.
Yes,
Is it fair to say that WPPI is not forced to purchase all excess generation under, I'm sorry, let me rephrase. I might need to request a recess, Your Honor. The information provided here in live testimony, it's not making complete sense to me in light of the characterization of the WPPI supply contract, and I think I need 15 minutes if you're amenable to review this and make sure that I understand the position taken here. This is not it doesn't appear to be consistent with the supply contract on its face.
Okay. Well, I'm amenable to taking a recess for that purpose, so we can recess for 15 minutes. I guess we'll get back at 10 to 1, 12:50. We can all arrange to get back here on time. That would be useful. So why don't we take a quick recess then? I'll just mute your camera, turn off your cameras and mute your mics. That'll be fine.
Thank you. And is it possible to get a transcript of what's been written so far?
Right.
You mean what we just did?
Yes. We have the recording, so we can review that.
Yeah, okay.
I could give you what I have, but it's probably, it's got steno in it. And so,
I don't know if that would be very useful, and I'm not sure if you can review the recording while we're live streaming either, but I guess take a minute to review the contract and see if you have any further questions based on that.
And
Thank you,
Your
Judge.
Honor, Your
Yeah.
Honor, to the extent it helps, I would just point folks to footnote 5 in the
we are off the record.
Yes, that's fine.
Yeah.
Correct.
Point folks to footnote 5 in the application, which talks about this de minimis exception, and maybe in the supply contract, page 16.
Okay, that would be useful. Okay, so let's get back. So it'll be 12. Let's do 12:55. It's back at 5 to 1. Thanks.
Thank you.
So that you know, when I edit, when I take a job, I have all these suggestions of how to write things, and I can't get it to go over to my other monitor, so it blocks out.
No, that's fine. Yeah,
It's just frustrating.
well, when I prefer when there's I mean, that question probably needed to be restated anyway, but it's the way, I've been, the way I've learned to do this is that don't want a question kind of hanging in the air. So if
Gotcha.
someone asks if someone asks to hear it again, I try to get you to restate it rather than questions, appear unanswered.
Yeah,
So
yeah.
that's why, and it just makes a lot more repetition on the record if we keep just re-asking things. So
Yeah,
hopefully
I
gives you a
got it.
little bit of a break too. I don't know if it's really a
Well,
break.
I'm trying to make it, I've worked on trying to make it smaller. I have a girlfriend that she said hers is really small. I don't know why yours is big, and it's just this big. Well, it makes sense to you, but it's like half of my screen. And I move it over and then I can see it, but then it bounces back and.
Uh-huh. Okay.
Anyway.
Well, but there's no big rush. If you need to, you can take your time to find what you need.
Okay.
Back. Yeah, I don't feel like you're under pressure there.
Okay, sounds good.
All right. Well, be back soon.
Okay.
All right, it's 12:55, so we're just admitting a few people that dropped off. Okay, so I suppose the question is to PSC, Attorney Rogers, are we ready to continue?
Yes, thank you, Your Honor.
Okay,
We would like to switch to the witnesses direct,
okay.
each three, please.
Make some adjustments here.
Thank you.
Oh, I got most of page 3.
We're looking at line 13.
There we go. Okay, we're in the right place then?
Yes, and
Okay, so we're back on and let's go ahead.
I'm gonna need to adjust my screen here. I'm not able to see the witness. There he is.
Cool.
Mr. Milner, returning to your direct testimony at page 3, the judge has a question up on the screen. The question was, how does the supply contract with WPPI affect the structure of SBU's PGS schedules? And you explained, as an all requirements member of WPPI, SBU is generally obligated under its supply contract to purchase all of its power supply requirements from WPPI. Thus, excess output purchased by SBU from COGS customers must be passed through to WPPI as WPPI requires, with the result that SBU purchases the same amount of power from WPPI that it would have in absence of the excess generation of a COGS in its system. And I have slurred a few words there, but did I generally read that correctly?
You did, yes.
And then you go on to say, and this is a statement that I'd like to ask you about now. You say, therefore, to the extent any cost is avoided, it occurs at the WPPI wholesale level rather than the retail SBU level. FERC has consistently held that the avoided cost to be paid the customer of an all requirements utility is the avoided cost of the utility's wholesale supplier. And then you go on to explain the FERC regulations.
Yes.
So based off of our discussion just before the break here, from what I'm hearing, this might not be, can you reconcile for me the statement that excess output, and I think I highlighted the wrong one actually. I think I highlighted the therefore. I meant to highlight. It's, Judge, if you are able to do me a favor and highlight end of line 13, thus excess output purchased by SBU.
Highlight, you mean to select it on the screen?
If you're able, just for facilitation, I would appreciate it. Okay, this is, and then at the end of that sentence in the middle of line 17. Okay, this is the sentence that we're having trouble understanding in the context of the discussion we just had.
The one that is highlighted
Right.
is, yes.
So I'm sorry, can we just have a question put to the record that the witness can answer?
Yep. In light of our discussion just before the break here, can you clarify that? Can you confirm? Do you agree that this sentence doesn't appear entirely accurate?
No, I think the sentence is entirely accurate, and I think that what might be tripping you up is as WPPI requires. As WPPI requires. And that's consistent then with the footnote 5 in the application, which is exhibit SBU Noldner 1, footnote 5, which explains the same thing. And it's consistent with the contract on page 16, which I think you looked at over the break.
I did, and I appreciate that citation. So what's tripping me up is I believe, and staff had understood from this testimony here that all excess output must be passed through to Whippy. And we're not accusing anyone of hiding anything. We understand that there was the supply contract, you know, this was discussed in there, but this is confusing and complicated. And so we did not understand that there was any generation that was actually not being passed through to WPPI. And so I will form a question. Now that you understand my confusion, or staff's confusion, can you clarify, and I didn't see this in the supply contract on page 16, can you clarify how much energy is not in fact being passed through to WPPI?
No, I cannot from the supply contract. That footnote, there is footnote 5 in the application, refers to the 43 kW cogs. So that's a fairly small one, and that is the size of the generator. A good share of the time, the load fully uses the generation. So there is not, you know, we could find it, but I don't know what that number is. We do have the right at WPPI to require that Sturgeon Bay utilities sell it to WPPI. And to this point, as also mentioned in the footnote, the expected, and I'm quoting from the footnote, and the expected administrative cost to pass through any residual monthly excess energy, if any, to WPPI would generally exceed the benefit available from the additional precision. That's talking about how that decision is made. If there's very small amounts, it costs us more to bill it than it helps the WPPI system. But we have the right to require Sturgeon Bay to sell it.
Okay, and so are you able to characterize how large of an exception this might be? Put another way, is it fair to say that most of the excess generation is being purchased by WPPI?
From where? You mean just Sturgeon Bay?
Yes.
No, not at this time, because that 43 kW cogs our WPPI is not buying that surplus from Sturgeon Bay right now. When there are more of these on the system so that it pays for the administrative cost to do so, we can and will, because we have the meter information.
Can you explain to me why should that 43 kW cogs avoided cost rate be set at WPPI's avoided cost when WPPI is not purchasing that power?
Because WPPI, when that surplus from the 43 kW cogs comes onto the system, WPPI avoids WPPI's avoided costs, and that's it. Is that clear?
I'm just gonna consult with staff and see if they have a better idea about how to ask the question. I think we might have what we need on that question. Your Honor, we do have some more questions on the Sir rebuttal testimony.
Okay. You can direct me to the,
Yes, and thank you again for facilitating with the screen share. Okay, so these are more straightforward. So Sir rebuttal, page 13, top of the page. Okay, for this one, is that page 13 I'm looking at?
12.
Oh, yeah, I think I have I might have an older draft. The second line there, furthermore, I'm just gonna read that back to refresh everyone's recollection. Furthermore, the decision would be controlled by the FTM cogs. And perhaps we should back up.
So off the record, can we just, can you summarize the context here and then give us, we don't necessarily need to read in what's already been offered in writing, but if you want to summarize the context and then ask your question.
Yes, thanks. Okay, I can go ahead.
You ready? Okay, let's get on the record.
Mr. Noldner, the top of page 13 here, discusses, the front of the meter cogs customers, and you indicated that they could simply wait for a year, depending on, their contractual obligation to lock in. Are you aware of potential parallel generation customers delaying interconnection, or operation of a COGS for an extended period of time in order to achieve a higher buy-in, locked buy-in rate? I'm sorry, buyback rate.
What we're talking about here is a proposal from Mr. Kell, I think. So the COGS customers haven't seen a price signal like is being described here, where 15 years worth of energy price would be locked in on one single historical year. So I don't see how that relates to whether I've seen a COGS do that or not, because they haven't been faced with that choice.
Thank you. I think that makes sense. And I'm not aware, given that this was responsive to Mr. Kell's testimony, I'm not sure, whether any other conversations have been happening, with those potential customers, beyond Mr. Kell's proposal. From what I'm hearing, the answer is no, you're not aware of any customer strategically delaying such a contract at the time.
That's correct, because they have no incentive. They have nothing to gain by it with today's structure.
Okay, thank you. That answers my question. And then just one more question for you. On page 16 of this server model, this one has to do with the avoided transmission costs.
Yes.
Can you speak to any quantitative analysis that's been completed to justify the $0 per kilowatt avoided transmission capacity value?
Let me put the answer to this in the context of what my testimony has said, and that is that the Public Service Commission has the 5 EI 157 docket open right now, and one of the issues in that docket is what the avoided transmission cost should be evaluated on a holistic basis. The commission has ordered the different investor-owned utilities to investigate that too. We are in the same position they are. We believe that it should be, the avoided transmission costs should be evaluated holistically. We think that to date, when somebody simply applies tariff rates to a change in load, is a shallow way to look at avoided transmission costs. It doesn't tell you that any transmission, in fact, has been avoided. So we need to involve the transmission owners like Xcel Energy and ATC to get a better read on what is truly avoided, and that the result is not simply a reshuffling of who pays for the cost of the existing system. So we have not done that holistic analysis.
Has there been any quantitative analysis done for a WPPI or SBU? Not, holistic or otherwise.
Okay, you said not. And then you interrupted yourself. So not holistic or otherwise, or just holistic as otherwise?
Holistic or otherwise. I'm sorry.
That's okay.
And I'm going to object on the basis that's compound, and I'm not sure what we're getting to or exactly how this relates to this portion of the testimony.
Can you just rephrase?
Absolutely. I'm mostly seeking a yes or no response to my prior question. Perhaps the court reporter could read back my question.
The very last question.
I guess the problem would be yes or no, but it's compound, we won't still have a clear answer. I'm not exactly sure if it was compound, but
The
go ahead.
You mean the question prior to that one?
Yes.
The one before that. And I would object only in the characterization of that one. The $0 is a placeholder. It is not a determination that the avoided transmission cost is $0. It is the same placeholder that was included in the IOU's tariffs.
Okay, and that placeholder, that's a theoretical, what you're expressing, it's a theoretical placeholder. There hasn't been a quantitative analysis done that leads to $0, correct?
Correct.
Thank you. The reason this does matter is because the placeholder, once it becomes an authorized rate, we're seeking to establish sufficient evidence to support that. So that's where I'm coming from in my questions. And that is it for this witness. Thank you.
Well, I thought part of your question was, maybe that's where it's compounded. Part of the question was any study done, regardless of the characterization of being a holistic study? And so I
Your
know
Honor,
the
I
witness had
apologize.
answered that the question was that there was no holistic study done. So I think we just want to get on the record that it was any study done with respect to avoided transmission costs.
Your Honor, my understanding was that Ms. Rogers withdrew that question and was trying to get a yes or no answer to the question before that one. And then I was belatedly objecting to the characterization of the question before that one as calling the zero a cost versus a placeholder.
Nice.
If I may, I think I lost track of my own question as well. And not unintentionally, of course. I'm not trying to confuse anyone with my own confusion. So for the record, can you confirm, Mr. Noldner, there has been no quantitative analysis to justify the placeholder $0 per kilowatt avoided capacity value?
That is correct. Yes, there has been no study to justify zero.
Thank you. Now I'll let you go.
No,
Okay.
it's
Not go. I mean, I meant from my own
yes.
tyranny.
All right.
Yeah.
So no further questions. Okay. All right. So that's so you're included your cross. Let's have redirect.
Yes, Your Honor, I'm deciding whether if things are going to get more confusing or less confusing.
Don't you love these parallel generation cases?
Mr. Milner, let's talk a little bit more about your the discussion you had with Ms. Rogers related to your direct testimony, page 3.
Struck out with those. Okay.
Thank you, Judge.
Right,
for
yeah,
pulling that up.
great.
And we are talking about generally those same lines, 13 through 18 that were discussed then. So in your discussion with Ms. Rogers, you mentioned that some confusion might be coming up with respect to the parenthetical on line 15 related to as WPPI requires. Do you recall that?
Yes.
And as WPPI requires in that sentence, what was that intended to refer to?
Whether or not WPPI would exercise the right it has in the long-term supply contract to make the purchase from Sturgeon Bay Utilities.
And then you talked about footnote 5 to the application.
Yes.
And is that the basis on which WPPI makes a decision as to whether or not to purchase?
Yes.
And that basis is the administrative cost to bill exceed the benefits?
I didn't hear what you said, sir.
I said correct. Yes.
Okay, thank you.
That's all I have.
Okay. All right. That's it then. Thanks very much. You're excused.
You, Your Honor.
So that's all of the SBU witnesses. We can move on to renew. Let's see. There's Andrew Kell on the list there. There you go.
Renew would call Mr. Andrew Kell, Your Honor.
All right, great. I'm going to swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? You're muted.
I do, and I apologize for being muted.
That's all right. You're gonna catch you one time or another. Go ahead.
Did you cause to be filed written direct and written sir rebuttal testimony, including the attached exhibits in this proceeding?
I did.
And are those true and correct to the best of your knowledge?
They are.
Okay, Your Honor. I pass the witness.
All right, so nothing new from Attorney Kell. Do we have, just wanted to be sure, I think I'd asked, yeah, so it's 14 exhibits so far filed, and then 15 will be coming in. Just want to make
Yes,
sure.
Your Honor.
Okay, great. All right, so do we have cross for witness Kell? Start with SBU.
No, Your Honor.
None? Okay. And commission staff?
Yes, Your Honor, just a couple of questions. First, starting with direct renew Cal 14.
All right.
And I didn't make a note of the line number. I apologize. It's line 4. So Mr. Kell, here in your direct testimony, you characterize and provide some background for commission staff's practices, and I just want to clarify for the record, that can you confirm I'm sorry, I didn't take a note here.
I can actually, this is a question that I had, so I can ask this if you.
That would be wonderful, thank you.
So I was curious, witness Cal, you characterize your testimony making statements about staff's practices in analyzing municipal rate cases. And I was just wanted to make sure we understand for the record that your experience only speaks to the past practices that you were involved with. You're not speaking to current practices that may be different.
That's correct, Your Honor. I was working on a retail rate analysis for the commission from 2017 until March of 2021, I believe.
Okay, and we don't have delineated to the extent that it's different now, but you can only speak to what you know. So, okay.
That's correct. Thank you.
All right, great, thanks.
Thank you, Judge. And then just one quick question on the sir rebuttal filing, sir rebuttal renew Cal 10. Well, a few questions on this spot. So starting at line 17, we have a question here. And in your response, you use the term neighboring retail customer. Do you mind defining what you mean by neighboring retail customer?
Sure. Generically speaking, talking about the nearest neighbors that are interconnected by distribution to the customer who owns the generation system.
And what is your basis for finding that all excess generation from COGS feeds into the distribution system owned by SBU and is consumed by a neighboring retail customer?
Sure, it's my general knowledge of how the distribution system works. If there ever is a system that is so large so as to bypass the substation owned by the utility, it could go feed into the transmission line. However, almost all systems will remain on the distribution system and be consumed by neighboring customers of the customer who generates the excess electricity.
And this is really the last question. What is your basis for then concluding on line 4 there that this reduces the amount of billable units to WPPI?
Sure. I submitted an exhibit that included the WPPI tariff that Sturgeon Bay Utilities pays to WPPI. And in that WPPI tariff, there are various charges that SBU is subject to, and it's related to energy and kilowatt hours, demand and kilowatts, and other charges. And if the energy that is normally would be a billing unit, let's say 100 kilowatt hours for SBU to pay WPPI is reduced to, let's say, 99 kilowatt hours, then that's 1 kilowatt hour difference in what SBU has to pay to WPPI.
Those are all my questions. Thank you, Witness Kell.
And just to clarify, so that tariff is that's Exhibit Cal 7, is that correct?
I have to double check. That is correct, Your Honor. It is Cal 7.
All right, thanks.
Your Honor, I may have some additional questions just based on that line of questioning. Could I have literally 15 seconds to pause?
Just to jump in there. Sure, that's fine. That makes sense. Go ahead.
Thanks. I'll be right back.
I think she disconnected herself. Oh, no, she's Sturgeon Bay.
Yeah, just muted. So off the record.
I was looking, well, yeah, I am. I was looking for her name and I didn't see it.
Yeah, I didn't understand she meant pause her. Yeah, but that's fine. Get it now.
Thank you, Your Honor, and sorry for confusing everyone by my abrupt disappearance. I have no questions.
Okay, so did we get that on the record then?
Yes.
Okay.
Just
All right.
I have no questions.
Oh yeah, we don't need the, yeah, that's fine. All right, so let's continue on with commission staff. Any more cross?
No, thank you, Your Honor.
That's it. All right, so redirect from renew.
No, Your Honor.
Nothing. Okay. So let's plug along here to commission staff and let's call our commission staff witness.
Commission staff calls Tyler Mellemans to the stand.
All right, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Mr. Mellemans, what is your position at the Public Service Commission of Wisconsin?
I'm the rates supervisor in the Division of Energy Regulation and Analysis for the Wisconsin Public Service Commission.
What is your role in this docket?
In this docket, I've provided commission staff's testimony and analysis of Sturgeon Bay's proposal to change their parallel generation buyback rates.
And did you cause or, did you file or cause to be filed the direct and rebuttal exhibits that we see on the judge's screen here?
Yes, I did.
And are the statements and representations in the testimony true and correct?
Largely, yes. I think I have a couple typos to correct. I'm not sure if we'd want to take care of that now or in a subsequent question.
Yes, I'm sorry, I wasn't clear. On the substance, is there anything that you do you agree with with the substance of what you filed earlier in this docket?
Yes, I do.
Okay, and we can go through your typographical corrections. Judge, I believe you instructed us to read those into the record today. Is that right?
Yeah, so the preferred method of doing that is through the errata, but if there are corrections, we should get it in the record now while I have a chance to review it. So let's go ahead.
Okay, and good to I hadn't realized that, so always learning here from you. Mr. Millimans, do you have the list of typographical errors that we identified earlier?
I do.
Great. If you can go ahead and please read those in.
Yeah, absolutely. So the corrections that need to be made in my direct testimony at page 5, line 5, there is a typo for the word accept. At
Which except
ooh, is there two?
ACC or EXC?
Just one moment.
I'm sorry.
In line 5 where it says exempt, it should be accept. So the second word there on line 5. Are we good there?
Yeah, proceed with your list.
Okay.
Great.
The next one in my direct page 6, line 21, there's an additional period that should be struck. Right after utilities.
Yes.
In my direct page 7, footnote 4, I incorrectly cited FERC order 872, and it should be citing FERC order in docket number QM 23-5-000. And then the last two corrections are on my SIR rebuttal. So the first one is SIR rebuttal at page 2, line 11. The word would should appear before appropriately.
Is it?
So it should read, this would inappropriately place a burdensome amount.
Okay.
And then the last correction is SIR rebuttal at page 5, line 20. There's a typo. We incorrectly use extant instead of extent. And then that is what I have for corrections.
All right, thanks.
Thank you, Mr. Melliman. Sorry, I didn't handle that for you on errata. That's all I have for Mr. Melliman's judge.
All right, and so witness Mumins, are you also offering the data request response exhibit?
Yes, I am.
And that's been on file. Also, we'll be seeing the public comment exhibit as well, correct?
Correct.
Okay, great. All right, so with all of those filings, they're all accepted for the record. I don't know if I mentioned all the documents we see on the list, the offered evidence list, that now that they've been verified and we have identified the places that they'll need to be corrected. With those corrections, they're all accepted for the record. So we'll just expect to see all those refilings within the assigned deadline, which, if my calculations are correct, should be Friday the 17th. Okay, so let's move on with any additional testimony from the witness. Anything else to add, Attorney Rogers?
No, the witness is available for cross.
Okay. All right. So any questions for the witness?
Your Honor, I do just have a couple questions.
All right. Yeah, go ahead.
And Mr. Millimans, they're in the same vein, I think, of what we were just talking about in terms of clarification / potential corrections, and relate to your SIR rebuttal page 3, the question starting at line 20.
Okay.
Okay, and in that question, you note that Mr. Noldner responded to your direct testimony, which expressed concerns about using the proposed 3-year average. And then you list a series of things after the 3-year average. The MISO day-ahead LMP, planning reserve auction, and cost of new entry as a basis for the avoided energy and capacity buyback rates. Do you see that?
Yes.
So first question is the reference to planning reserve auction, planning resource auction.
Yes, that should be planning resource auction.
Then the second question, did you intend to reference the cost of new entry in relation to the use of a proposed 3-year?
I'm sorry, you broke up on my end. Did you intend?
To reference the cost of new entry in relation to the proposed 3-year average?
Not sure that I follow the question.
Mr. Noldner's testimony discusses the use of a 3-year historical average for day-ahead LMPs, correct?
Yes.
And for planning resource auction results, correct?
Yes.
If I were to represent to you that it does not include a 3-year average for the cost of new entry, do you have a basis to refute that?
I do not think I do. That may have been an accidental inclusion in that list.
And that's kind of just what I wanted to clarify. So no concerns with removing the reference to cost of new entry associated with a 3-year average.
Just provided on my follow-up review that there is no mention of a 3-year average of Cone in his testimony. I would have no issue removing that.
Thank you. No further questions.
Great. Questions from Renew?
No, Your Honor.
All right, and any redirect?
Judge, may I have an opportunity may I have a few moments to review what we might have been citing to and clarify any confusion there?
Sure, yeah, that's fine.
Thanks.
We'll just go off the record.
Okay, I'm back, Your Honor.
All right, back on the record. Any redirect?
Mr. Milliman's upon review of rebuttal SBU Noldner 3. Do you see any reference to a 3-year average of Cone?
I do not.
And so
Of Cone.
Cone, C-O-N-E.
Thank you.
And were you referring to a piece of testimony, or I'm not sure if I heard the citation correctly.
The citation was rebuttal SBU Noldner 3. And that was the basis of your Sir rebuttal, the portion of your Sir rebuttal, and upon checking, you can confirm that Attorney Lair is correct. There is no reference to a 3-year average of Cone.
That is correct.
Thank you.
All
And
right.
thank you for the extra time.
Okay, is that it?
That's all the redirect I have.
All right, great. All right, thanks very much. So I think we have all of our testimony in. May be helpful just to review the schedule because it has changed. So just bear with me a second. So because the hearing, today's hearing was not anticipated, the scheduling order, or scheduling order, I believe, was it the deadlines ordered previously have been shifted. So I can just give you a listing. I can probably be best just to show you, though they go fortunately backwards from soonest to latest. So the draft transcript, you'll see that on the 16th. We don't have any affidavits, but the revised testimony would be due on the 17th. You'll see proposed corrections to the draft, May 21st. Objections to those proposals, May 23rd. Initial brief, May 29th, and reply brief, June 5th. So that's on the electronic docket calendar, if you need to review that. And also on our case management system, you can see this screen through the case management system. So any questions or outstanding items we need to review? No? All right. So at this point, we're adjourned. Thank everyone for your participation and take care. I'll see you next time.
Thank you.
Thank you.
Judge?